I've been asked to comment on the issue of the choice by the government of nominating the Senate President, Christine Kangaloo, as their choice for President of the Republic. Now, firstly, when one looks at the issue from a legal perspective, I will say at the outset that there is nothing legally wrong with the government making such a choice. And in fact, such a view is fortified and in fact enshrined within our very own Constitution, because when one looks at the sections of the Constitution which deal with the president and the appointment of a president, it is pellucid from section 24 of our Constitution that the framers of our Constitution actually envisaged the possibility that someone who is a member of the Senate or a member of the House of the Representatives can be elected as president. Section 24 says, where a member of the Senate or the House of Representatives is elected as president, his seat in the Senate or the House of Representatives, respectively, shall become vacant. So, it is clear that the framers of the Constitution considered the possibility that someone could be a sitting member of the House of Representatives or a sitting member of the Senate and still be appointed as president or nominated for such an appointment. So there's nothing at all legally wrong with it. So it is clear that the government is on solid legal ground in making such a decision. Where it gets interesting, of course, is apart from the court of law, where the government is clearly on solid ground, there's also the court of public opinion. And based upon what persons have expressed, since the naming of their choice, it is clear that some consideration ought to be taken as to, hearing the views of others, because we must all remember that as far back as the 1936 case, right, the Privy Council case, 1936 Privy Council case of Ambad versus Attorney General, right, this was a case from Trinidad and Tobago, right, and in that Privy Council case, Lord Atkins made it clear that one must always look at these situations with an open mind. In fact, Lord Atkins, in that case, that Privy Council case of Ambad versus Attorney General, said, justice is not a cloistered virtue and must be allowed to suffer the scrutiny and the respectful, even though outspoken, comments of ordinary men. So, in other words, we, in looking at this situation in Trinidad and Tobago, have to listen to and be willing to hear the comments of ordinary citizens on the matter. And of course, the government can then decide whether they take those into account or not. So in the court of law, the government is very clear and they are on solid ground. That's backed by the Constitution itself. Section 24 actually envisaged the possibility of a member of the Senate or a member of the House of Representatives being nominated for the post of president. In the court of public opinion, I urge the government to have regard to the Privy Council case of Ambad versus Attorney General, where Lord Atkins made it clear that we must still, even though, you are on solid ground legally, we must still be open to hearing the views of others. And of course, you then make your final decision based upon that. We, however, bear in mind that once you venture into these areas of morals and ethics and whether it's morally right or ethically right, the words of former Prime Minister Basdeo Panday, when he made it clear that politics has a morality of its own. So we wait to see how this matter plays out in the public space.